Madam Deputy Speaker, sorry. I have genuine respect for the way the Honourable Gentleman has developed an interest and followed in great detail the issues to do with rendition and over the last few years. I think it's a cause that he himself says he's taken up with some surprise, not having expected this to be so close to the centre of his work, and I have genuine respect for him on that basis. However, I refer him to the answer I just gave to my right honourable friend in respect of the paragraph that he cited. Also, I said earlier, I'm not going to join a lobbying campaign. Because the Obama administration, no, my job is to make decisions. It's your job to offer opinions, it's our job to make decisions. I'm not going to join a lobbying campaign for a very simple reason. The Obama administration have made clear not just their abhorrence of torture, but their determination to do everything they can to change the image of the United States around the world in this respect. They have a choice to make about many aspects of intelligence that they have to decide whether or not to release, in the same way that we do. They will not release it if it compromises their sources. They will certainly not release it give their accession to its release through a foreign court. And I think that is the right approach. This administration has made clear, in a way that the right honourable gentleman would probably argue, the honourable gentleman would argue, the previous administration didn't. This administration has made clear its determination to clear the name of the United States. And in that context, I think it's right to give them the scope to make a decision about all the issues they face, which are far from confined to this particular case. I'd remind the House that there are a number of outstanding legal issues in the United States system at the moment on issues relating to this, and every case has to be seen in that context.
David Winnick.
Is my right honourable friend aware that for many of us, the core of this matter is simply this: Mr. Mohammed's claim that he was cruelly tortured abroad and that British security agents knew and colluded in what occurred. Now, if this is so, and I note what the Foreign Secretary has said about the Attorney General's inquiries, if this is actually so, then surely the values and the rule of law that this country and this House is so proud of was betrayed. That's the seriousness of the issue, and one which, obviously, we want an answer as quickly as possible.
Well, Madam Deputy Speaker, I agree with my right honourable friend. These are very important issues. They are issues that go not just to political questions or moral questions, but actually judicial questions. And it's a question of criminal wrongdoing that has been referred to the Attorney General. And therefore, I think it's right that we allow the Attorney General, as quickly as possible, as he says, to come to her conclusions.
Sarah Tether.
I recognise the Foreign Secretary's role in arguing for British residents to return to the UK, and I thank him for that, as he is well aware. However, I'm very disappointed to hear him repeat again that he will not join in a lobbying campaign to get allegations of torture released into the public domain. Does he not recognise that it is the Foreign Secretary's job to argue for British interests and values abroad? He says he is against torture. Surely he should be using every power at his disposal to ensure that allegations and evidence of torture is put into the public domain.
Madam Deputy Speaker, there's a fundamental confusion in what the right honourable lady said. First of all, over the position of the US government, which, far from denying that they are against torture, is actually celebrating the fact that they are against torture and want to do everything they can to make sure it's expunged from the rhetoric and the role of the United States. Secondly, I do have to repeat to her, I'm sorry to have to repeat it to her, but there remains a fundamental distinction between justice for individuals and the general case of the public interest about the revelation of in public of secret information. We have to make that decision about our own information. The US will make that decision about the information they hold on the basis of whether or not they think it furthers their goals, which we share, of campaigning against torture, or not.
Lynn Jones.
Right honourable friends share my concerns that the former US administration was prepared to use torture to extract information from detainees, information which by definition must be unreliable, and yet ignored reliable information provided by one of the UK's top agents, Michael Shipster, that through his source, a long-standing source at the highest level of the Iraqi government, that the Iraqi government did not have weapons of destruction, and also provided a credible explanation for Saddam Hussein's reluctance to admit as such.
Madam Deputy Speaker, I was with my honourable friend for the first half of her question. The differences that existed between this government and the previous administration were discussed widely over the specific issue of waterboarding and whether or not that constituted torture, and that exemplified the position that the government took, and I think was shared elsewhere in the House, that waterboarding did constitute torture. So our own position on this is absolutely clear. We're signed up to international conventions and covenants, never mind national laws in this respect. I think the Iraq question is for another day.
Sir Patrick Cormack.
One who believes that the Foreign Secretary has made a wise judgment and given a balanced statement to the House, and who expects the Foreign Secretary, our Foreign Secretary, to lead and not to lobby, can I nevertheless ask him for two assurances? First of all, would he make it abundantly plain that the Intelligence and Security Committee will indeed have the 42 documents which its chairman indicated they have not yet seen? And secondly, would he give an absolute undertaking to this House that if, as a result of the Attorney General's investigations, it appears that any member of the British security forces has indeed engaged in torture, that person will be brought to trial, and in the hope that he or she would be punished very severely?
Yes, Madam Deputy Speaker, in respect of the 42 documents, the commitment of the government is to work in an open way with the ISC. It's a very important part of our system, and it's a part of our system that I think works well in holding to account some of the most sensitive aspects of government. In the end, the decision about prosecution is obviously a matter for the Attorney General, but I'm sure she will want to, and the DPP, the Director of Public Prosecutions, and I'm sure they will want to discharge their duties in accordance with the full and open law of the land.
Tony Baldry.
The Foreign Secretary will be aware that in 1863, President Lincoln issued an edict that stated that military necessity does not admit of cruelty, nor of torture to extort confessions. But in December 2002, Donald Rumsfeld did just that by authorising interrogation techniques which clearly violated Article 3 of the Geneva Convention. And does the Foreign Secretary agree that nothing has so damaged the moral authority of the United States and her allies as the use of torture and extraordinary rendition?
Yes, Madam Deputy Speaker, when I said in a different context that before this House that democratic countries are held to a higher standard than terrorist groups or others, and those standards are in our interest. And when we violate those standards, we let ourselves down in a very, very serious way. And if he's referring to Abu Ghraib and other matters, he's certainly right that did a huge amount of damage, not just the moral standing, but the political position of decent people everywhere.
Peter Bottomley.
Would the Foreign Secretary decide to send the report of these exchanges to the United States and ask them to make available a summary or redacted version of the documents, which seems to solve the particular problem? And does he also regret that the government waited until 2007 to take up the issue of the British residents, rather than responding to the pro bono lawyers working for the Guantanamo people who asked them to do it rather earlier?
The honourable gentleman raised an interesting point. It's certainly the case that up until the end, I think, of 2005, or certainly through 2005, the focus of the government was on bringing back the British citizens, the 9 British citizens. And we wanted to work very hard to take into account that experience before moving on to the separate class of issue, which is to do with the former residents. And it was in that context that the Home Secretary and I were presented with the work that had been done when we took office at the end of June 2007, and then 5 weeks later we were able to take the decision to apply for their release. And I can assure him that from previous experience of these issues, the exchanges in this House are watched very, very carefully by our closest ally.
Sir Robert Smith.
Thank you, Madam Deputy Speaker. There will be some confusion in many of my constituents' minds about exactly what the role of the Foreign Secretary is, because surely intelligence sharing and the protocols that go with it mean the decision rests with the United States, but that doesn't prevent him from making representations on behalf of this country to the United States. And surely that is what the role of the Foreign Secretary is, to make representations on behalf of this country.
Absolutely. Madam Deputy Speaker, I can only think that the honourable gentleman wasn't listening when I described, and when the court described, the extensive, in their words, strenuous efforts of this government to secure the return of the individuals from Guantanamo Bay. If that doesn't constitute standing up for the national interests of this country, I don't know what does.
Philip Oliver.
Really special bit about our special relationship with the United States is our intelligence sharing, and the Foreign Secretary is quite right to defend that. But will the Foreign Secretary understand the concerns of my constituents, that this man isn't even a British national? He's taken legal proceedings against the British government, who seem to be doing their level best to return the man to the United Kingdom. And will the Foreign Secretary recognise the concerns my constituents have, that this man is creating all sorts of problems for us as a country, despite our doing our best efforts to get him back to this country?
Well, I'm not sure. I think that I'd prefer to stick with the fact that the position that we have taken, which is to seek the release and return of Mr. Mohamed, is actually the right thing to do as a former British resident. I'm sorry if he can't support us in that aspect, even if he does recognise the overall importance of the links between the US and the UK.
Order, order.